and its failure. In other words, as I said, parties reach it themselves, it works, it's a success. Courts order it, it's unsuccessful. It causes more divorce litigation. It causes increased child support litigation. It obviously causes far more custody litigation. Some couples become codependent with the courts and are in there daily in motions court, which many times you do daily, or 3 times a week. And you're there every day. And you have to appreciate, and again, I've sat there, I've probably tried 300 custody cases, what's going on there. My daughter's 14, and my ex-wife allows her hem to be too hot. It's raining outside, and my husband sent the child, my ex-husband sent the child to school in a jacket that was too light. Courts can't do those things. And the underlying problem is not the hem or not the jacket, it's the conflict. And so that's what we have to do. Now really briefly, Oregon went to presumptive joint custody in 1997. And I'm not going to go through the litany of what the researchers found, but one commentator in the Florida State Law Review 2007 declared the law on the basis everything they saw to be a failure. Iowa, Tennessee, and the state of Washington have all either adopted presumptive joint custody or considered it and backed off in light of the comments that the commentators and the social scientists have engaged in. They expressed the doubt of the wisdom in presumptive joint custody in the cases that the court sees, which is the high conflict case. And I keep saying, we want everybody to go out and do it, but don't ask us to enforce it. Even Australia tried it in 2006. They passed it as a national law. And in 2008, the Attorney General of Australia called it a failure. So it's been proven to not work all over the United States. In those cases where the parents just cannot be child custody, cannot be child-centered and reach cooperation. One other interesting note, in those places, those states I've mentioned, in the countries where they tried it, the research shows in about a year or so, people go back de facto to the primary custody, partial custodial relationship, because it just works better for everybody. And perhaps there's also some gleam that the presumptive joint custody is not working for the children. So with that, with looking at a child-basic system and noting that presumptive joint custody, in my view, has not been successful where tried. And therefore, I respectfully do oppose House Bill 463. Say that for what it's worth. I hope it's self-evident. The question is, what do we do? And I didn't want to come here and be destructive, and so I wanted to make some suggestions. And what I did is I sort of tried to do what I always do, which is think outside the box. I think as if I was writing on tabula rasa, and putting a system I went together. And I have a suggestion for you. First, I don't think we have to abandon best interests of the child. But I do think we have to define that term and say what it means. And one of the statutes that Representative Mandarino makes an attempt at that, I think that's a laudable attempt. I think a lot of those categories are very good. But let me anchor it more simplistically. And to try to get a system that is child-focused and contacts with both parties, both parents, while at the same time reducing high stress. Start with what's known as the approximation rule. The term comes from the American Law Institute, which writes many of the uniform laws that the legislature has adopted in Pennsylvania and everywhere in the country, and is generally a think tank on the law. And it has the principles for family dissolution, and it's termed the approximation rule. All that rule says is the post-separation arrangements, as far as possible, should mimic pre-separation arrangements. Now, there's obvious advantages. Kids are losing their most fundamental grasp on what they know. Their mom and their dad being under the same roof, co-parenting, them running into each of their mom and their dad's arms as they come home. Let the kids stay in the same home. Don't move them out of that home. Let them stay with their same friends, in their same school, in their same church. with their same doctors and dentists and neighbors. So approximate at the moment of separation what was occurring before separation. If mom brought the kids off to school, let mom get the kids got off to school. If dad picked them up every day after school, let dad pick them up. It's easy to predict the result, which reduces litigation. It should reduce conflict, and it should work well. And that's a bias that I would suggest to you as you go forward to suggest this. The other, and I'm sorry, but the 5 more minutes, I've seen it keep it clock. I was going to digress, but I'm not going. All right, now we have the parents living apart, but we have them in an approximate relationship. What do we do next? What do we do next? All over the United States, we're using parenting plans. In Pennsylvania, we haven't used parenting plans. Again, it comes from the American Academy of Matrimonial Lawyers, adopting from those ALI principles, which I commend to you. Colorado, Minnesota, Washington, D.C., and Indiana all use parenting plans to allow parents to participate in the process of arriving at what arrangements should occur for their kids. The plans differ based upon the age of the child, because we know that very young children should see the parent they're not living with all the time for short duration. Older kids can see the teenagers can see the parent for a long time, spaced farther apart, because they're able to adjust to that. Indiana has a system that I personally like very, very much. They've developed parenting time guidelines, and they're available on the net. I have a set here. I'd be glad to leave with you. They're based upon social science, child development science. I don't know how good their science is because I'm a lawyer and not a social scientist, but we can check that. We have many great universities that have child development departments. And what they do in Indiana is they use their parenting time guidelines, which again use social science, that are age appropriate and scenario appropriate, to assist parents to adopt a parenting plan so that the parents are involved. I presume in a high conflict case that they have to litigate the conclusion, but then the court would use the parenting guidelines as a basis. So we would not have wildly diverse results. Courtroom to courtroom premised upon judges, well-intentioned but individualized judgment. I think that that's a wonderful idea as we progress from approximation and go forward. Interestingly, the social science shows the presumptive joint legal custody does work and does help, and you should be aware of that. It allows the non-custodial or the partial custodial parent more psychological investment. The issues are concrete, they're limited. Generally, the children are not caught between them. And if somebody really can't focus on what's best for a child, the court can change from joint legal custody to sole legal custody on the dot in 5 minutes in motions court. So they can be child-centered if they help. The other thing parenting plans have that I commend you to look at is they require in the parenting plan some sort of dispute resolution system. Hopefully not the court. Put together a panel of 5 relatives, maternal grandmother, paternal grandmother, maternal aunt, and whoever, and let them listen to the grievance and let them vote secretly 3-2, one way or the other. And then we'd at least have the family, the village, raising the child, and not the state raising the child. Minnesota, Arizona, Oregon, all these parenting plans with various tweaks. And as I said, I like the Indiana model, and I commend it. Now finally, in conclusion, as I run out of time, and I could do this for about 3 hours, the Joint State Government Commission put together a very, very thoughtful and excellent proposal. They mimic the Connecticut model, which is and it's used by more than Connecticut, which is a services model. I like that model also as an amalgam with everything else we're talking about. Now, we've used services in Pennsylvania for years. Almost every county has educational programs, mandatory educational programs for people going into custody. That's a service. A lot of counties have mandatory mediation, although some don't have mediation.